That's why I think we're here. Is that why you all think we're here?
It is, Judge. I guess my only question would be how you want to proceed with this. My client filed his motion for contempt and to modify the parenting plan first in time. In response to that, we got the CR 60 motion asking to set aside the contempt that we're here on. So I normally we take that CR 60 first, but again, I don't think it matters because everything's closely intertwined and related. So I'll leave that up to you as to how the court wishes to proceed.
Thanks. Ms. Green, any comment on that?
Your Honor, my same question is how you wish to proceed since there are several matters.
Yeah, I think my preference would be to go in the order that I announced and to hear the CR 60 motion and then the motion for contempt and then the motion to modify.
Okay.
So let's jump right in. I've read the briefing, so I have the copies of the documents here and I've taken notes on the same. So I'm happy to hear arguments from both parties.
Thank you, Your Honor. So regarding the CR 60 motion, my client filed that within the year required by the statute. My client filed it based on fraud, misrepresentation, and other reasons justifying relief. My client felt that the CR 60 motion was necessary because the rulings made in this matter were excessive, unreasonable, and not based on the facts in the case. The first issue my client had was regarding the severity of the penalties. There was a threat of potential jail time if she violated again. There were costs asserted against her for the prevailing party for attorney's fees, but there was no consideration given to the financial ability of the parties or the financial need of the parties, which is required by the statute. Additionally, the court found that my client was violating.
The hearing opens with the court clarifying why everyone is here. Multiple motions are pending, and even the attorneys acknowledge overlap. The judge takes control immediately, choosing a clear sequence: first the CR 60 motion, then contempt, then modification. That decision matters. It sets the framework for everything that follows. The court confirms it has reviewed the briefing, taken notes, and is ready to hear argument. This is not a cold start. The judge comes in informed. From the outset, the tone is procedural, deliberate, and controlled, signaling that the court intends to methodically address each issue without distraction or emotional detours.
The decision-making clause by unilaterally engaging the child in counseling. The counseling the child was engaged in was previously ordered by the court and had continued since the previous order of the court, which was actually made by Your Honor. So as far as her making unilateral decisions in counseling services, that did not take place. The child had continued counseling from a prior court order. The issues that father brought up were his lack of contact with them. Their not having contact with them was found not to be truthful because there's communication in the record that there hadn't been contact from father about counseling service whatsoever. So the basis that was made on was erroneous by the court based on the false evidence presented by Mr. Curtis about his involvement in the counseling. Regarding mother removing the child from school, that violation was provided ample evidence that the child was in counseling, therapy, and other treatments during the school time. Those medical appointments were all provided in the record.
Mother's counsel begins by framing the CR 60 motion as timely and grounded in fraud, misrepresentation, and excessive penalties. She argues the prior contempt ruling was unreasonable, unsupported by facts, and financially punitive without statutory analysis. Jail time was threatened, attorney fees imposed, and financial ability allegedly ignored. Counsel challenges findings related to counseling, school absences, and decision-making, asserting the child's counseling was court-ordered and documented. She disputes claims of lack of contact, derogatory comments, and school violations, emphasizing records contradict father's assertions. The argument consistently returns to one theme: contempt requires clear, proven violations, and counsel insists that standard was not met.
The reason the child had missed school and the tardies were related to the child's bag checks after the knife incident that was in the court's record as well. So nothing my client did took the child out of school excessively that would have applied for a violation under the statute or under the clause that she had violated the excessive amount of unknown reasons, because father was aware of the bag checks, father was aware, child was going to counseling. There was nothing that father was unaware of or that was excessive in the in the child's care that would have amounted to contempt on that issue. Regarding the derogatory comments, most of the incidents that were based on or that were found as derogatory comments violations weren't actually any comments whatsoever. Issues brought by father showed violations based on derogatory comments for.
The CR60 argument expands to the mental health evaluation. Counsel emphasizes it was not specifically requested in pleadings, only referenced in declarations. She characterized the requirement as judicial overreach, unsupported by evidence of danger or misconduct. Financial infeasibility is raised, citing furlough and government shutdown constraints. Importantly, counsel ties this back to the CR60 request, arguing that without valid contempt findings, the mental health evaluation cannot stand. The presentation is structured and comprehensive, touching every finding challenged. By the time counsel concludes, she has positioned the CR60 motion as both procedurally justified and substantively necessary to unwind what she calls a flawed contempt order.
Stating that the pocket knife was somehow a derogatory comment against father. It's an act that mom did not actually provide the pocket knife and did not make any comments to the child derogatorily to father. His statements are all based on supposition. He wasn't there and doesn't know the circumstances surrounding the child getting the knife. So using that as a basis that was used to harm father against the child was not appropriate, as well as other facts of basically changing the child's name. There was nothing provided by father that showed that was either derogatory towards him or that it actually occurred. All these were all statements made by father, and based on the statute, there has to be ample facts, even if in light of the favor of the probable contemptor, that there has to be ample facts to show that the client was in contempt. My client was not in contempt. All these violations.
Father's counsel responds by anchoring the court firmly in history. He points back to Judge Haas' July 2024 contempt order, emphasizing the court's expressed concerns at that time. He stresses what did not happen afterward: no motion to reconsider, no request for review, no clarification. Silence, he argues, lasted nearly a year. Only after new contempt and modification motions were filed did the CR60 appear. Counsel challenges the timing as unreasonable, even if technically within 1 year. He frames the motion as reactive and strategic, not corrective. The argument is direct: CR60 relief is extraordinary, and this case does not meet that standard.
Violations were not amply proven and were disputed clearly in the record. Finally, the other issues regarding the mental health evaluation that was required. The biggest issue is that there was nothing provided in the pleadings that requested that. It was not in the motion. It was only in declarations as reference only that the mental health evaluation needed to be completed. It is an example of overreach. There was nothing in the contempt that showed that there was a need for mental health treatment for my client. My client is in mental health treatment, and at this point, it is financially unfeasible for her to complete the mental health treatment. She's on furlough, and due to the government shutdown, there's no way for her to complete it. That'll go into the next motion, but I do want to state that for the record that there has been no no finding that was substantial enough to show that mother needed to complete a mental health assessment and that she's in any way danger.
The timing issue becomes central. Father's counsel walks through CR60's language, emphasizing reasonable time alongside the 1-year limit. He argues waiting nearly a full year, while allegedly not complying with the order, undermines the motion's credibility. He stresses the need for finality, especially where a young child is involved. Counsel also highlights the mental health evaluation delay, stating it has been outstanding for over a year. To him, the CR60 motion is an attempt to sidestep accountability. He characterizes it as retaliatory and bordering on bad faith, ultimately requesting denial of relief and an award of attorney fees due to the procedural posture and timing.
To the child, if the contempts are not found in light of the CR60 motion, then there should be no need for the mental health assessment, which is the next issue in the case.
Very good. Thank you, Ms. Green. Mr. Sandy?
Again, I think this one largely speaks for itself, Your Honor. This was a case that was heard by Judge Hahn, not this past summer, but again, we're going back to July of 2024. It's a case where the court had very significant concerns about the conduct of Ms. Nguyen. I think if you reviewed that contempt order from July of 24, you can clearly evidence that. I don't know how far you got in your review of this, but if you look at the declarations in that contempt, if you look at the exhibits in that contempt, I think it was all crystal clear as to what was going on. The court did impose again and signed off on that order back in July of 2024. At that time, there was no motion to reconsider. There was no request for a review hearing. There was no clarification.
A brief rebuttal follows. Mother's counsel acknowledges delays, but attributes them partly to her own documented medical issues, noting they appear in the pleadings. Father's counsel counters, stating intermittent illness is the only reference in the record and disputes broader explanations. The judge intervenes, confirming his recollection aligns with the pleadings. This exchange is restrained but telling. The court limits discussion strictly to what is documented. No speculation. No expansion. With rebuttal complete, the judge transitions away from advocacy and into analysis. The tone shifts. Arguments are over. The ruling phase begins, and the court methodically outlines the legal framework governing CR60 motions.
That was requested from Ms. Nguyen or her counsel. We don't hear anything. And again, I think this is going to dovetail with kind of the control mechanism that you kind of get here ad nauseum today about the issues with mom. We don't hear anything until after we file our latest contempt and after we file the motion to modify the existing parenting plan, that then they spring this CR60 motion. The CR60 motion, now we're hearing about furloughs, we're hearing about these types of things, which again aren't contained in the pleadings. I'd ask the court not to consider that. We never heard about that certainly in July of 2024. And again, if there's no request for review on a motion to reconsider, again, I think the court has to deny this. And again, I think from a legal perspective, if you look directly at CR60, I think it's pretty clear. It states in part, the motion shall be made within a reasonable time period. And for reasons 1, 2, or 3, not more than 1 year after the judgment, order, or proceeding was entered or taken. What that tells me, and typically we see CR60s on a final basis. What this tells me is that the rule is contemplating it's got to be number 1 within a reasonable time period. So if you look at the history of this is a contempt order. To sit on that and wait almost to the day, a full year before you file the CR60, realizing that you as a party or you as an attorney, your client, is not complying with that order, again, is not reasonable time period. If a CR60 was to be filed timely, that would have been within a month or 2 after a review hearing, after a motion to reconsider, And again, we have none of that. This is now trying to whitewash basically the history of this case and say, well, here we are once again in trouble for which, and again, I'll address this on my contempt argument, pretty egregious violations of a clear order. And to kind of skirt that, well, I'm going to try to now file this CR60 under this 1 year time limit, which I would agree. You do have up to 1 year to do that under normal circumstances. But the circumstances here are not reasonable, given this is just a contempt order. And we've got a young child who needs finalization on this. We got two parties who have been going at each other in litigation now for an extended period of time. While my client has been waiting, I have been waiting. And again, I'll get to this. The GAL has been waiting for over 1 year now for this mental health evaluation with a parental risk component, with input from everybody that we haven't gotten. So we're sitting here idly by, and then we get a CR60. Clearly, this is retaliatory. I think that's obvious. Clearly, I think it's in an unreasonable time frame given the clear language of the statute. And again, I think this is one where it fails both factually and legally from both precedents. If anything, this was Judge Hahn's order. I think it's crystal clear. It's very easy to interpret. We just have somebody who doesn't want to do it, and now she's looking for backdoor ways that she can try to circumvent the clear order of the court. Again, and eliminate any responsibility on her behalf. So essentially, and I know that we are loath to find bad faith, frivolous pleadings and the like, but I would think this gets as close to that as it possibly can, given the circumstances and the timing of this. We are asking for $1,000 in fees. Again, I just don't think this is made in good faith. I think the evidence is pretty clear to that. And again, if you look at the timeline, it's